So you can go back and kind of review parts that, if you want to review. That's just because we're trying to provide education. We're not trying. We are actually doing it, man. We're providing all kinds of education. And today is no exception to that. We are going to be providing education about estate planning, wills, trusts, etc. Today, specifically, I have some other topics that I've been putting together. When you do this, like I do every day, I just always have these questions in my head. And the thing that really popped into my head in the last probably month or so from dealing with several cases is what makes a successor trustee who takes over for their mom and dad, for example, what makes them believe somehow that they don't have to keep records and account for somebody else's money? And that troubles me, because I would imagine if anybody asked you, hey, would you be willing to take my checkbook and my bank account login information, and would you, take care of my stuff for me, like pay my mortgage payment, pay my utilities, make sure my insurance is covered? Would you take care of that for me? Would you not have in your mind, oh, I should write this down? Okay. Now, some people do and some people don't. And I'm not faulting them for that. I just want successor trustees to know, if you are a successor trustee, mom and dad passed away, you're now taking care of their financial situation, which is kudos to you, man. That is a big job. It's a hard job. Okay. It's a thankless job, because no matter how great of a job you do, your beneficiaries are going to be saying, well, this would be better if, and when can I get my this? And what, that's the way it works, because that's the world of fiduciary accounting. That's the world of taking care of other people's money. So if you're the successor trustee and you're hearing this and go, wow, Gary, that's pretty, that's kind of harsh there. Well, if you are a successor trustee and you have not been keeping good records, or you're not good at keeping records, now's the time to do that. Because you're going to be required at some point in the future, or soon or later, you're going to be required to account. And every time I go to probate court on trust accountings, on probate accountings, on probate battles, on trust administration battles, over fights over inheritances, and when am I going to get my money? Why is it so small? Or, why'd you sell the house? Anytime I'm in those battles at court, the judge always wants to know, where's the accounting? Where's the accounting? What have you been accounting for? I want to know where every penny is. And the judges are not super forgiving about that. They want to know exactly where the money is. And that's because the successor trustee's job numero uno, that's Spanish for number one, is to account. And it's not hard. It is literally a matter of keeping track of it. If you're the kind of person that doesn't keep a checkbook, that doesn't really balance your bank account, that doesn't put things in Quicken or YNAB or anything like that, and you just don't track your expenses, well, if you're the trustee, that's no longer an excuse, guys. Now's the time to step it up and take care of your finances. I was just talking to a financial guy, does financial planning. The guy's really smart, and he was asking questions about budgeting. How much you spend on this? How much income do you have? All these different questions. And his comment was, most people don't budget at all. Okay. And then I know for a fact that there was a study that came out, and I believe it was a big school. It was like Harvard Business School did this survey, as if they were the ones that had to do it. And they determined that only 10% of Americans, 1 in 10, have a budget of any sort. And of the 10, only 1 uses it. And to me, that was like, wow, we hold our government to a standard of budgeting, right? They always go over budget, but at least they have one. So why do we not budget? Why do we not keep track of our finances? It's not a dirty word. The coolest thing about budgeting is, as you go and budget your money, you see it grow. You put your money away. You have like auto draw to go to a bank account. I mean, that's why I started investing, is I thought, you know what? I'm never going to do this. So I am going to put $58 a month into an account at an investment house. And I did it. And then I decided to increase it up to $58 a week. And it's, that's not a lot of money for most people. It's just not a lot of money. It's $58 a week. It's, whatever, it's $10 a day, $11 a day during weekdays. That's, for a lot of people, that's lunch. And I started doing that. And it was really funny because it's like 10 years now. It was a lot of money. I was kind of surprised. $58 a week. I mean, the reason it's a funny number, thank you for asking, is because if I did 50 or $4.99 or $49.99, I'd go like, oh, that must be some subscription that I have for iTunes or something. But it's 58. That's a weird number. I can't remember exactly why I did that number, but it was 58 and it worked out. And it's just been an auto payment. So I see it, it's in my budget, blah, blah, blah. Okay. So the thing about budgeting, I thought it was very interesting that he said not a lot of people do. I will tell you though, as a successor trustee, you don't have a choice. Your legal obligation is to account. So if a dollar comes in, you put it in the books. If a dollar goes out, you put it in the books. If you're going to write it on a handwritten ledger, fine. You're going to put it on a spreadsheet, great. If you're going to put it in Quicken or some whatever program you have, there's tons of them out there. Yeah, I'm not talking about QuickBooks, which is kind of a challenge, or if you don't know how to budget, then hire a accountant or a bookkeeper or a tax professional and say, I need help with this, and then give them the records and let them do it, because you get paid to do it as a trustee. You get paid. You don't have to do it for free, and it gets paid out of the trust, which you are accounting for. Okay. Number two, if this is more not as obvious, it's more subtle. If, let's say, your parents are both to a point where they just can't manage their money. I mean, mom is subscribing to every magazine, 12 years in advance. And you go like, Mom, you're terrible at your finances. You can't see as well as you used to. I don't want you to trouble yourself with this. I want to take care of it for you. And then you start taking care of it. And then it gets to the point where mom is incapacitated. Like literally her doctor says, you shouldn't be driving. You shouldn't be managing and making financial decisions. If your mom's at that point, that's when they're incapacitated and you need to be keeping a track of everything. Okay. Because what will happen is later somebody's going to ask you, give me the accounting. And is that going to be because she's now in a conservatorship or she's passed away, or we need to determine, if she's qualifies for whatever. It's really important to keep track of things, keep track of finances. So if you step up as the successor trustee of your parents' trust, whether they're incapacitated or deceased, do a good job. And I'm happy to help you with that. That's what I'm here for. That's why we're talking about it. 855-500-TRUST. If you need help being a good successor trustee, I'm all over that. I got a great team that'll help you. 855-500-TRUST. If you're behind the 8 ball and you think you should have been getting an accounting, please don't wait. Call us. Let's figure it out. 855-500-TRUST. Coming up next, we're going to be talking about taxation on trust and estates and things to do as a trustee.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Car.
So, Gary, we've talked a long time about estate administration. So, what is that and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor. That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. They'll have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to be a successful and good successor trustee. We also do the required notifications. We notify the Department of Health Services and all the legal requirements so that they can have the estate administration done properly. We help successor trustees be successful.
Call or click to request your free consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, GQLaw.com.
You're live. Welcome to the Word on Wealth. So good to have you guys along. It's really a fun day that we're having here talking about wills, trust, estate planning, trust administration, and probate, and all the things that we want to avoid talking about, but we all know we got to find out how they work because it affects all of us. Every one of us should have a will. Every person within the sound of my voice should have a will at a very minimum, and the will would at least do a couple things. One, it would declare what your will is, and that is who you want to get your stuff after you pass away. It will do number two, most important, it will define who would be the guardian of your minor children. If when you pass away, you have minor children, it would designate who would be the guardians. That gives them, those named people, the legal authority, the legal priority to petition the court to become the guardian. So there's still a court petitioning process. It's not just a gimme. And they've got to go and prove, that they're a good person and all that kind of thing. But the court process is enhanced and made a lot more streamlined, and it goes faster because you have designated who would be the guardian. If somebody decides to contest it, they're a lower priority. Okay, if you have no will, therefore no guardian designation, then anybody in your family, hopefully somebody, will petition the probate court to become the guardian of your minor children. And what happens with that is everybody in the family gets a notification that Johnny and his new wife, Susie, are going to try to become, the guardians because they want to do that. And then the grandparents step in and say, wait a minute, I've got way more money and I've raised children before, and these are my grandchildren, and I don't want anybody raising them, especially my son-in-law's, sister or whatever. But what happens is, as you think everything's going to be fine and dandy, oh, they'll just work it out. That's baloney. They don't work it out. They fight it out. And your kids are going to be pulled into that. If you do not designate guardian, then there's going to be a fight because somebody has to step up and give everybody in the family notification. And that's when everybody starts to question, like, oh, you only want to be the guardian because there's a $500,000 life insurance policy. We know you. That's a bad way to start the relationship with all the people that now you're going to be the guardian taking care of the grandchildren, okay? Or this niece and nephew. If there's a will, however, on the other hand, the will says, I want my sister-in-law, I want my, my big daughter, whoever to be your guardian. That named person has the legal priority. So we know what your will is. Your will is that you want this particular person to raise your children in the event that you can't. That's a simple thing. Okay. So if you have minor children, you got to get a will at least. And if you're traveling over the holidays and you think, oh, I don't want to do one more thing. I just don't want to think about one more thing about these Christmas parties and office parties and all these things at church. And I'm trying to put this on and be a good person and serve my neighbor. And I don't have time to think about a will or trust or power of attorney, all these things, Gary. And I have this vacation plan. We're going to Spain for Christmas and we're leaving in like a week. To which I will respond, well, are you taking your children with you? Yes. Well, then you need to have a guardian designation. And that's got to be done in one of two ways. You either do it through a will, create a will that has a section in it that designates a guardian, or you can do a nomination of guardian form. There is one free on my website. It's literally on my website, gqlaw.com, and it's in the section called free stuff. I believe it is free stuff. I know. And you go to that section and there is a nomination of guardian form. When you click on it, it just downloads it. You print it out, you fill it out, you sign it, you have witnesses sign it, and then you leave it out available for whoever is going to be around, maybe when you're not. So that nomination of guardian will give them at least the authority to petition to become the guardian of your minor children.
Interesting question, Gary. I'm not sure if there's a simple or a complex answer to this, but do things change? You just mentioned, vacation, going international. Do rules in trusts and wills change when families kind of move around, perhaps outside of United States jurisdiction?
Yes, good question. Outside of the United States, it's completely different. For example, I was talking to somebody just last week, and they have property that's in Mexico, and it's like a vacation place in Mexico. I don't even remember where it was, but they were trying to put that in their estate plan, and the dirt, wherever that dirt or property is located, has to go by the rules, the laws where that property is actually located. Another situation, you're here in the United States, you have your trust, you live in California, and you own property in San Antonio. Well, the San Antonio is in Texas. That's controlled by Texas law. We can still have the trust, say that Texas property is supposed to go to, this person over here. We can still do that.
Can you have a trustee outside of the country? Like, so for instance, could I have my friend per se in Spain be my designated trustee?
Would your friend be a U.S. citizen?
Okay, well, let's speak to both. Maybe he has either dual citizenship or he doesn't. No, maybe he's just in Spain.
Okay, if he doesn't, then no, can't do it. They have to be a U.S. citizen. So if they're dual citizen, they could do it because they're a U.S. citizen. They could perform the duties as a U.S. citizen.
Gotcha.
It's going to be hard internationally. I mean, it's totally possible. It's just, the documents and everything has to be signed and open a bank account, get a tax ID number. That can all but getting some of the physical stuff like a bank account, that could be handled. Because it's by the same thing. It's like if somebody lived in Arizona, it's the same thing. They want to be the successor trustee. They live in Arizona, which happens all the time. People live out of California. So if the person died here in California and their property's here in California, then the successor trustee they perform their duties here in California, even if they live in another state. Even if they're a U.S. citizen living in another country, it's going to go under the California law. So those are great questions. Great questions. And people will ask me also, on that same vein is like, well, Gary, okay, so I downloaded your form for a nomination of guardian and I filled it all out, but we're going to move to, we're moving to Washington next month. Will it still be valid? I don't know. I'm a California attorney. I can't even really answer that, but it's better than having nothing. When you get there, find an attorney, a competent estate planning attorney that you trust, go through the interviewing process, find somebody you like and trust, and get an estate plan, whatever they need in that state, because they're a little bit different. Every state handles things a little bit differently with property. So you're gonna, people will move and they'll ask me, okay, Gary, I have my home here and we bought a house in Austin and we're going to move to Austin and live in the house. Is my trust going to still be valid? My first question is, what are you going to do with your California property? Oh, we're keeping it. It's a rental. Well, of course you're going to keep it as a rental because rentals in California make a fortune. So they're going to keep it as a rental. They're going to move to Austin. Do they need to keep their trust? The answer is yes, absolutely yes. Because why? California property is controlled by California law. California law says if you don't have a trust, your property is going through probate. I don't care where you live. If your property is in California, it will go through probate unless you have a trust. So yeah, you would still keep your trust. California property, make sure you have a California trust. Those are good questions. All right. I wanted to talk a little bit about taxation of inherited IRAs. If you've inherited an IRA for somebody, so your dad leaves you an IRA and beneficiary designation says it's going to Noah, all right? So if once Noah gets a hold of that IRA, it's not an IRA for him, it's an inherited IRA. Even if his dad had a 401k or a 403b or, whatever the plan is, if it's a retirement account that is tax deferred, which most are, that retirement account converts to an inherited IRA. And the Secure Act, which I love that. Like, it's actually kind of a misnomer. It's an acronym and a misnomer. So it'd be like a misacronym. I don't know if that's a word, but it says secure, which is, it's really not what it means. But yeah, the Secure Act made it so that if you inherit an IRA, you have to pull it out within 10 years. And there was the wording is that you have to have it out within 10 years. So people were thinking, well, I'm still working. I'm not retired yet. I'm making good money. I don't want to pull it out right now because if I pull out some amount of money this year, I'm going to be taxed at a really high rate because I'm in a high tax bracket. I'm going to wait until I stop working so much, or I don't have a good year, or I retire, and then I'll start taking that money out. I'll get it out before the 10 years. I just don't want to pull fully taxed retirement money out of an inherited IRA while I'm making money. So then the IRS came out with rules 2 years later and said, oh, no, you were supposed to be taking out required minimum distributions. Well, the Secure Act specifically says that the requirement for the requirement for required minimum distributions, that was just gone. You don't have to take out RMDs, and you don't have to draw on your Social Security or your retirement account until you're 72. You can leave it in there until you're 72. So some of those changes sounded like, oh, a good idea. But what happened now is the IRS says, well, wait a minute, that's not what the rule means. It doesn't mean you can take it all out on the 10th year when you're not making any money. You have to at least take out what you would have taken out under the old rules, which would be a required minimum distribution based on your age. So if it's $100,000 account, yeah, let's just do that. If it's $100,000 account under the old rules, if you're like 65, the rule is that you have to take out like 1/22nd, or let's say
2 minutes.
Yeah, 1/22nd, because based on my age and the chart we looked at, I would have to take out 1/22nd of that account, and the next year I'd have to take out 1/21st, and then 1/20th, and then 1/19th. It kind of goes like that. So I would have only had to take out 1/20th. But it would be an RMD. So then the IRS started to say, okay, well, you have to have taken out an RMD. So the example of Noah inheriting an IRA from his dad, and it's $100,000, he'd have to take out an RMD, which would be probably 1/20th. So it's like, what is that, $5,000 in the first year? Okay. And then the next year you could do basically the same. Well, then the IRS changed their mind and said, no, wait a minute. We really want it to be taken out in even installments over 10 years. So you have to take out 1/10. So like your RMD is 10%. So now what do you do? It's been 2 years. The IRS changed their interpretation of the rule. You've been taking out 5%. Now they should be taking out 10%. And so now you're behind and you got this penalty and all that. So the rules with RMDs and under the Secure Act with inherited IRAs are very specific. Get with somebody who knows what they're talking about. If you want to talk to me about it, it's 855-500-TRUST, 855-500-TRUST. You are required to take money out of an IRA if you've inherited it. And right now, the recent changes, the IRS is trying to say you're supposed to take out 1/10 every year so that by the end of the 10th year, it's out. You're not taking it all out in 1 year. that causes problems with taxation and income levels. Oh my gosh. If you want help with it, give me a call. All right. Coming up next, I think what we should talk about is, what if mom writes a letter and just says, hey, divide up all my stuff. And, it's like this handwritten letter, and you're trying to figure out, well, does that work? Does a handwritten letter work? The trust says something different. Her will says something different. And there's this handwritten letter. Let's find out how that works. Coming up next here on The Word on Wealth.
You've got questions.
My guess is if the date on the letter is different and more recent than in the trust and it's notarized, that's okay? Yes or no?
Expert
You're
estate
gonna find
planning,
out.
trusted
Ooh, I gotta wait. Suspense.
and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com. At GQ Law, 855-500-TRUST. Or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQlaw.com. 855.
You're back.
Welcome to The Word on Wealth, my friends. This is Gary Quackenbush. I am a California attorney and happy to be here with you today talking about your wealth. We do it every day, Monday through Friday. On Friday is a very special show. We talk about mental health, mental wealth. We call it Feel Good Friday. We got a really special guest coming up on this Friday, same time on these same two channels, 4 channels. And we're going to be talking about some issues with charities, like the charitable car donation program and things like what happened with those, how do they work now, that type of thing. And he's going to be part of our show, which is super, super exciting. So that's coming up on this Friday. Tomorrow, I'm on with John Burrows. We talk about mortgages and the housing market. That'll be fun because there's been a lot of changes in the last week, some announcements coming out, and John helps us make sense of all those things. Then on Thursday, as always, we've got Anthony Wright, who is the retirement guru, financial advisor extraordinaire. He is so fun to talk to. He's got his own radio show. He's just a really good, solid, Christian, nice, good investment guy. And we have him on, and he does fantastic for his clients. I've talked to a couple of his clients who are like, okay, he's just phenomenal. And I like that. So he's part of our show. He's one of my partners. He'll be on Thursday. So today we're talking about estate planning specifically. That's my bailiwick. That's my wheelhouse. That's where I do my thing and understand everything that I need to know about estate planning. Specifically, two different things. Want to talk about what if mom has a trust, okay? And at least we think she does. So mom passes away, and the kids have been telling each other, oh yeah, mom has a trust, mom has a trust, mom has a trust. And now you can't find the trust. You have looked everywhere. You have tried to pull up carpet squares to see if there's loose floorboards or there's some secret passageway. You're pushing on the bookcases, running screwdrivers in all the grout between the bricks. You're tapping on the walls to see if there's anything hollow, and nothing happens. You cannot find mom's trust. But she always said, I've got you kids taken care of. Do not worry. I've got you taken care of. So you're thinking maybe she has it in a safe deposit box. So you call her Bank of America. Hey, Bank of America, my mom, we're looking for her trust, and we wanted to know if it's in her safe deposit box. How are they going to respond? They're going to say, oh, well, get a court order and we'll tell you whether she has a safe deposit box, because we can't talk to you. I'm sorry. We can't even acknowledge whether your mom is our client or not, because that would be disclosure of confidential information, and we can't do that. So sorry, we can't talk to you. Get a court order. What? A court order? How do you get a court order over something you don't know? So you can go to the judge and say, hey, judge, we're not sure whether she has anything at Bank of America, so we just want an order allowing us to talk to Bank of America. The judge is going to say, I'm sorry. Unless you know what it is specifically in the value, then there's nothing I can do to help you out. So we're kind of at a dead standstill. We need to find that trust, and we can't. All right. We know she has a house, and the house title says it's in a trust, but we can't find the trust. If you cannot find the trust, there is no trust, period. The law in California makes an assumption that says if you cannot find the original trust, and it is presumed to be to have been in the presence or the possession of the trustor, that's the last place anybody knew it existed, it's presumed destroyed, meaning the trustor, your mom, would have just torn it up or thrown it in the fireplace or gotten rid of it, threw it in the trash because she didn't want it to exist, because she would rather have it go through probate and make the distribution a different way, or she was changing her mind, and in the middle of changing her mind, she passed away. I don't know, but you got to find the original. If you find a copy, then you've got to go to court. You notify all the beneficiaries and particular heirs and say that we have a copy of the trust, and this copy we want to be declared an original so that we can do the trust administration and distribution and accounting process. And if a court says, okay, we can do that, we're going to say that the file is in, the trust is in, the copy is the original, and we're going to use that as the original, then we're good enough. If, though, you're petitioning the probate court for that, you may be able to get the court to give you authority to now go talk to the bank to see if you can actually find an original. And then if you find an original, then you can go back out of the probate court and say, okay, never mind, thank you very much for your help, and go on from there. But you're going to have to get probate court. You can't just get an order from the court to go into the bank. You're going to have to open a probate based on as if the trust didn't exist. Okay. What if one of the kids says, well, mom does have the trust. That's too bad we can't find it. But here, I got this piece of paper from her, and she wrote out here, I want my kids to have all my property in equal shares. I want my house to go to my daughter, Susie, because she's single and she needs a place to stay. And I want my car to go to my grandson, Evan. So we're going through this list. It's like, well, wait a minute. We don't have a trust, and we've got this letter from mom describing what she wants done, and it's not even signed. And we know mom wrote it. It's mom's handwriting. She's not faking it. So this really is her, some declaration. And so what do we call it? Do we call it a will or a trust, or do we call it a power of attorney, or, what is it? What is this thing? And if it's not witnessed or signed or anything, then it's really nothing. It's kind of It's something we're assuming. We might be able to go to court and prove that that's mom's signature. And maybe there's something where all the beneficiaries will agree. Well, we could follow this document. We're all okay with that. And then you could try to get it admitted to probate as if it were, some instructions, or it shows the intention, because it's not a will. If it were a will, to be declared a will, it has to be signed by your mom. So mom would sign it and date it. It would be very clear. She wouldn't have it witnessed. She doesn't have to have it witnessed. Holographic wills are usually not witnessed because we don't want anybody else writing on the document. We want it to be just the person who wrote it out in their own writing and then signs it, that's their will. And we could probate that holographic, we call it, will. But a letter from mom saying, I love you guys very much. Everything's taken care of. I just want to make sure you guys are dividing up everything evenly, but I want you to take care of your sister because she's not as fortunate as the rest of you guys, and she's not doing as well, and she's not married like you guys, the rest of you guys are. And I want her to have my house. Well, first of all, mom, that's not even and equal. You're saying divide it equally and give the house to the sister when the house is, 75% of the estate. So is everybody going to agree to that? Can we actually get that admitted to probate? It will require probate. You cannot just do it based on that. Okay. Why not, Gary? Great question. So let's say the kids all got together, they had a powwow, and they said, you know what? I know this is what mom wanted because she told me that. And they all agree. Big old thumbs up. Okay. House is going to go to sister. Everything else gets divided 4 ways. All right. So you go and you whip out a piece of paper and you create this thing called a quitclaim deed. And it says that, mom, deceased person, transfers the house to sister. Okay. And then it's got to be signed and notarized by the owner of that property. And the owner of that property is mom. Mom is deceased. Not possible. So what do? We now have to go to probate court to get an order from the court declaring that someone, whoever is the one that petitioned, that someone has legal authority to serve as the administrator of that estate. The administrator then will get an order at the end of the probate process, an order to transfer the house to sister. Okay. So it can happen, but written instructions not signed are really bad.
1 minute.
It's more like what I call a wishing letter. I like stuff like that as far as instructions would be to kind of, tell mom that, or to tell the kids like, okay, this is what I want for my funeral. And this, I want this to happen. I want my jewelry to go to this person. I mean, letters to direct the little stuff, those get followed quite often because that's really helpful in determining what's going to happen. In fact, as the as the executor or successor trustee, it's nice to have stuff like that to tell you what mom wanted, so you don't have to guess. So I like stuff like that, but it's not going to be her estate thing. If she has a trust, you have to have the original. What does that mean? If you're listening to me on this show and you do not have an original of your trust and you searched everywhere and all you have is a copy,
Now a minute.
You need to get a restatement. So that means you're going to go back and we're going to look at your trust and say, you know what? It's 10 years old anyway. It's done its job. Let's do a new trust. And we're going to create a new trust that has the same date. So if it was a, 2020 trust, it's still going to be called the November 2020 trust because the deed to your house says it's in the 2020 trust. And all we're doing is we're creating a new trust document to give instructions on what's supposed to happen. It's called a restatement. It's an amendment and complete restatement. Then when that's all done, signed and notarized and witnessed, you can throw away that old copy because it's not going to do any good. You keep the original of the new restated trust and you can make copies and hand them to your kids or do an electronic copy or whatever. But that's how you do it. You got to have an original. If you want help with this, always give me a call, 855-500-TRUST. Please call me, 855-500-TRUST. Let's help you out with it. We can get you an original trust. We can get it all set up. Don't go without an original trust. This is Gary Quackenbush coming up next. Let's talk about...
You don't need to know everything.
That's my bad for kind of screwing you up there.
when you need them. Welcome to the Word on Well with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
EQ Law are experts at solving IRS and state tax problems.
You going to be at the office tonight or on the phone?
Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. gqlaw.com.
You're live.
So yeah, mom has this bag and it says on it, I give everything all my stuff to my housekeeper, and you go like, wow, that's kind of crazy. Mom had her own will and we thought that was a good thing. And we're trying to, figure out what mom wanted because she wrote in her will that everything's going to be divided between the kids. And she said the car could go to her son and her jewelry can go to her daughter. And that all makes a lot of sense. And then we're in probate on this will. And suddenly somebody comes trotting into court and says, interesting. I have this brown paper bag here because before mom died, well, let's do it. Before grandma died, she said that she wanted me to have all of her property because she knew that I was taking business classes and I'm really smart and, I really don't have any money and I needed a leg up and she doesn't have that much anyways. It's only like $400,000 and she wanted me to have it. And she wrote it down right here on this paper bag. And it says right on there, I want my entire estate, all my property, everything I own to be sold and given to my niece or my granddaughter, Susie. Why is the granddaughter always named Susie? I don't know. But would that hold up in court? Great question. Thank you for asking. Assuming that we could prove that the paper bag was legitimate and that really was mom's writing and signature, and that mom was competent when she did it, the paper bag wins over a regular will. Dun, dun,
Now that's
dun,
kind of
dun.
what I thought, Gary. And here's another question that maybe makes this easier. If mom does that, should mom say, hey, you know what? Let's get this notarized?
No, that's a good question.
Oh, really?
No, because what in California, when you're looking at a holographic will, one of the rules is that it has to be completely in the person's own writing. Like, let's say this is the reason. So let's say that the granddaughter's there, and grandma says, yeah, you need, you got this idea for a business, for an upstart, and I really think, my kids don't need it anyway. I'm just going to give you everything. Get me a piece of paper. Oh, this is all I could find, grandma. Okay, write this down. I, comma, Susie Johnson, comma, give all my, and the niece, let's say the granddaughter writes it all down. Okay, grandma, is this what you wanted? Let me read through that. Okay, yeah, this is exactly what I wanted. And then she writes on it, I declare that this is my last will, whether she does that or not. And then she signs it. Okay. It was written out by the granddaughter, not by the testator, we call it, not by the grandma. So granddaughter wrote it out and handed it to grandma. There's an automatic presumption of overreaching. So the presumption is the will is invalid and it shouldn't be used. And that's going to be, it's hard to overcome that because that's one of the big violations. It's like, well, gosh, that seems really overreaching. I mean, it was a paper bag written by the girl who's going to benefit from all of it, and then signed by grandma, and the granddaughter witnesses it, or, it's notarized. It doesn't really matter whether it's notarized. The notary is just coming in and saying, yep, I identified her. She's grandma. She's grandma, and she's, she knew who she was. She knew where she was. She knew who the president of the United States is. So yeah, I'm good to go. And that's not enough to say, the notary's not there to say, hey, do you really want to give everything to your granddaughter, the girl that's standing right here next to you? I mean, that's not their job. And they're not good for that. I mean, that's kind of sounds funny, but that's not their job. Legally,
that's good clarification.
Yeah, they don't do anything else. So if you're going to do a holographic will, it's like everything you write it out by hand. You can type it out too. That's another weird one. Like, well, what if I type it out? Well, if you type it out, you better get witnesses. But if it's all in your hand, then we know that you wrote it and you signed it.
Does it help to date the letter at all?
Well, it's dating is important to have a date on the letter so that we can tell when it was created. Because in the case of the holographic will, if the holographic will predates the original, like regular official will, the official will trump it. It'll just get rid of it.
That was what my thought was.
Yeah.
So that's a way for you to prove, hey, you know what, this is the most current version of what mom wanted or what grandma wanted.
Exactly. And we'll do that too. Sometimes we'll have an estate where there's we've had things where there are like 3 different wills, which is really weird. I mean, we have a will, and the one that got brought to us was like 2 versions ago. And this is back, just some people don't have trust. I don't think it's a great idea, but I don't mind. I mean, I've made my career and sent kids through college doing probate. So it's obviously good for me as the attorney. So I don't mind you guys going through probate and having just a will. I don't mind being your probate attorney, but my kids are already through college. So let's just do trusts. So with the, you have this situation where if somebody came in with a will and we're probating the will, we're trying to put this thing together, go through probate and transfer the property. And then somebody comes in and says, oh, wait a minute, here's a will she did a year later. It's like, oh no, well, that first probate's not even valid because there's a new will. And then there was a third one that came in that was dated like 6 months later. And we're trying to see the genesis of the will. Well, that's where the fight starts. It's because, the first will, all 3 kids were in there. The second will, the third son that's using all kinds of everything he could sniff and smoke. And so the mom takes him out. And then in the fourth one, he gets the entire estate. Or the third one, he gets the entire estate. Then it's like, oh, okay, we're going to court on this one. That makes no sense at all. So, but the latest dated one is presumed to be the desire of the testator, the desire of the person that died. So all these things, it's funny. These are the things that you really don't want to have happen and you don't want to see. You want to try to get your estate plan so that it's right and that everything is witnessed and notarized and get it done properly. We can get away with we can prove a lot of things in probate court, but we're trying to avoid the probate court thing. We're trying to not go to court and not spend money in attorney's fees and time and delay and taxes and all that garbage. We just don't want that. So we're trying to get our estates in order so we don't have to worry so much about what's happening after someone passes away. So, yeah, notes. And the other thing with the note, and we'll have a lot of people that will they'll have a note. Well, here's a note from my mom, and my mom said I could have the car. Okay, the note is dated and everything like that, and the mom said you could have the car. Well, that's all fine and good, but the car is in the trust. I mean, we look at the title of the car and it says, Johnson Family Trust, Susie Johnson Trust. The car doesn't belong to the individual anymore. So if she wrote a note that said, I give my car to my granddaughter, and there's no car in her name, the only car they have is in the trust, that note doesn't even apply, because now you have to look at it and go, well, the best it could be is like a suggestion, like, hey, would you guys mind giving the car to my granddaughter? Because it's not legally binding. The trust owns that car. The title's in the name of the trust. So these outside documents don't really apply. So they're going to be like secondary evidence to help us figure out what to do with that. But the mistake that people will make is trying to give away big things with notes. And if you say, grandma's ring, okay, that's kind of pushing it probably, because there's some value there. What I prefer, if you're going to give away personal property, like specifics in a list or a note or a letter, then that you reference that in the will. So like a will that I would create, there's a paragraph that I like, and it's in paragraph number 8. But what it does is it says, I, meaning the trust, the testator, I have created or may create a will, a document or a list or a schedule to direct the executor in the distribution of certain items of personal property. I want I'm going to keep this will, I'm going to keep the list with my will, original, signed, and I want my executor to follow the terms of this list in distributing the items of personal property. And if there's any default in that or whatever, then it just goes to my trust. But I'm literally putting a paragraph in the will that says, look for a list. If you have the original list signed by me, kept with this original will, then the executor is directed to follow that list in the distribution of items of personal property. That would be like jewelry, clothing, small stuff like that, maybe some household goods and trinkets that you can give away by a list. Super organized.
2 minutes.
If there's no list, the default is everything goes into the trust. Everything gets poured over the trust. So that's how you use the list. Make sure it's referenced in your will, and some attorneys reference it in your trust. I particularly like to put it in the will because it's more changeable. So the list can be created by you later at any time, but that is what will guide your successor trustee or your executor in the distribution of those items. So there you go. Holographic, handwritten, all that stuff. We want to avoid it. Get your estate plan in order. Give me a call, and I'm happy to take care of it for you at 855-500-TRUST. Talk to you tomorrow with John Burroughs, all about mortgages and housing here on The Word on Wealth.
So 1 minute.
And then when John comes on tomorrow, so things that happened in the market is the rates stabilized, but then you probably heard today that the market went down again. So the Dow's all over the place. And I'm curious to find out from John tomorrow, how does that affect the housing market? I talked to a realtor friend of mine who was saying that, yeah, the prices dropped and they're kind of like creeping back up. There's a lot of deals out there to be had if you keep with it, because people are still motivated to sell for different reasons. But his suggestion, and I want to see if John would agree, was if you're looking to buy a home, just be patient and work hard and just kind of hit the pavement, make lots of offers, find the ones you want, talk to the sellers, and just kind of be chumming with the right people to get the things taken care of. So that's going to be on tomorrow. And on Thursday, we got Anthony. Friday, we got our show with our new charity we're going to talk about. This is Gary Quackenbush. If you want more information from me, the easiest way to get a hold of me is go to my website, gqlaw.com. That's gqlaw.com. Get my free book, Living Trust Basics, and all my other free stuff that I give away right there on gqlaw.com. Talk tomorrow, everybody, here on The Word on Wealth with Gary Quackenbush.
Tell a friend about The Word on Wealth, featured since 1995 with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help you preserve your family's financial future. Information you hear on The Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual